Hello, everybody. My name is Liz Gallagher, and I'm a paralegal at Liles Parker. Welcome to today's webinar hosted by the Home Care Association of Louisiana. Today's webinar is entitled Avoiding Criminal Liability, Views from a Former Prosecutor. Today's presenters are John Pierce and Robert Liles, and I will give you a little background on them. John Pierce is a partner at Liles Parker. He is an experienced former federal prosecutor and trial attorney whose practice focuses on sophisticated criminal defense and civil litigation. Prior to entering private practice, Mr. Pierce served as an assistant U.S. attorney in the Southern District of California, the District of Columbia, and in the Eastern District of Virginia. While working as a federal prosecutor in the Eastern District of Virginia, he represented the office on the Attorney General's Advisory Committee, AGAC, for healthcare fraud. Since leaving the government, Mr. Pierce has successfully represented both foreign and domestic individuals and corporations in healthcare, commercial securities, corruption, export control, and tax disputes. He has also handled a number of whistleblower cases. He has prosecuted antitrust claims worth $1 billion, defended corporate clients in commercial litigation, conducted internal investigations, and plenty more. So that's Mr. Pierce. And Robert Liles is the current managing partner at Liles Parker. In addition to a law degree, Mr. Liles holds both an MBA and an MS in healthcare administration. Mr. Liles has worked on the provider side as a federal prosecutor and now represents home health, hospice, and other healthcare providers around the country in connection with Medicare, Medicaid, private payer audits, and False Claims Act cases. And now, without further ado, I will pass it over to our speakers, Mr. Pierce and Mr. Liles.
Thank you, Liz. Hey, John.
Good afternoon, Robert and everybody.
Today we're going to talk about how to stay out of trouble. And we're very lucky to have John Pierce on this presentation with us. I've known John for many, many years. I first met him in the 90s when, as Liz said, he was on the Attorney General's Advocacy Committee, which is a big deal because he was on the Committee for Healthcare Fraud. And that is normally composed of presidentially appointed U.S. attorneys, but in his particular case, his office, they managed somehow to send him. So he was instrumental in coming up with the policies that a lot of the DOJ U.S. attorneys' offices went forward with in the 90s and 2000s. So we're going to talk with John today and really get his perspective about what you can do, whether you have a home care agency, home health, or hospice. What can you do to stay out of trouble? And to begin with, we just want to provide an overview of enforcement. One of the things I want to point out, and John, I'd like for you to weigh in on this. John, if you remember at the very end of Bush 2, the beginning of Obama, when we had the bank crisis and all the banks were going under and we had to spend billions of dollars to prop them all up, to make sure that because of really improper lending practices, the economy just didn't completely collapse. John, can you think of a single person, an individual, who went to jail because of those wrongful acts that the banks committed?
Isn't that interesting, Robert? The economy of the entire world collapsed and not one individual was held criminally responsible for that catastrophe.
But that's not the case today, is it?
Well, it's not the case in financial fraud because we continue to have financial frauds, but it's certainly not the case in healthcare fraud. The Department of Justice has shifted a focus to any time there is corporations that commit wrongdoing, which, for instance, led to these bank collapses in the late aughts. Now that the government wants to focus on the source of the problems when these things happen, and that's people, the people working for the entities that cause a financial catastrophe like that. So certainly in healthcare, the government is not willing to just take a guilty plea from an institution and move on. They want to hold the people accountable that caused whatever decisions were made that created criminal conduct by a corporation.
And that really kind of makes sense, doesn't it, John? Because what is a corporation but just a fictitious person? A corporation can't really violate the law. It's people within the corporation that violate the law and engage in wrongful conduct.
Yeah, and that really goes back, Robert, to when we were in the Department of Justice. It was much more commonplace for when it was a white-collar crime, the government and defense counsel would figure out a way to come up with a settlement that caused a big fine to be paid or fine and restitution to be paid, but it never touched the decision makers in the C-suites. So that's where the shift has come, is to move away from that old line way of resolving disputes in the white collar world to today the government certainly trying to recognize who's at fault, not what's at fault.
Yes, I agree completely. Next slide. Now, one other thing that I'd like to run by you, John, is, John, when we were in the department, and this is going back a ways, of course, under Attorney General Reno, one of the things that really caught everyone's attention was when she said that healthcare fraud was the #1 white-collar priority for her administration. And that was a big deal at the time. Now, no one since then at DOJ has ever made any type of statement that even comes close to that. But when you look at the numbers don't lie. This is just looking at the numbers for DOJ's criminal fraud section. This is not incorporating all the prosecutions at the different 94 U.S. attorneys' offices around the country, but let's just focus for a second on some place that we can get the numbers from. Looking at the fraud section here in Washington, D.C., you'll see that the number of healthcare fraud cases prosecuted and the number of convictions, they more than double all the other white-collar areas being prosecuted by DOJ. So, healthcare fraud, that is the focus. While DOJ's not touting it like Reno did, healthcare fraud is where it's at for DOJ, for prosecutors today. Would you agree with that?
I do, and I think it goes back to, as you stated, when Attorney General Reno focused on healthcare fraud. It was because the Medicare Trust Fund is this huge devotion of resources and treasury funds to take care of particularly the elderly and others in this country with their health care. And I think the point that I want to make to the listeners is that healthcare fraud is a little bit different animal, because in our system, there's a third-party payer almost all the time. It's either Medicare, it's either a government healthcare insurance program like Medicare, or it's private insurance. So the third party is never privy to what actually takes place in the patient doctor relationship. So if a patient is a payer and goes in for treatment, the patient knows exactly what happened, and if there's a difference in what comes out on the invoice with what the patient knew was done or needed to be done, the patient can confront the doctor and take care of it right there. Not so when it's a third party involved. So this trust factor of what providers submit for payment to insurance companies, particularly Medicare, that trust factor is what the government really wants to be held sacrosanct, so that if there is any gaming of the system, they want to be able to enforce their laws, and they do so. And that's why I think healthcare healthcare fraud has developed as the #1 white-collar focus within the Department of Justice.
I agree. Now, it's interesting because we've been talking about the federal side, but one thing that's happened, and I think you would agree with this, John, just in the last, 5 to 10 years, we have seen the states kind of stand up and really grab a hold of Medicaid fraud cases around the country. And in fact, you and we're defending at least 3 Medicaid fraud cases right now involving personal care. So, this is something that states are becoming very, very active in. And one thing to kind of keep in mind for the folks on the phone, I know you're from Louisiana, but the fact is that all states, of course, have a Medicaid fraud control unit, and including, all states plus District of Columbia, Puerto Rico, and the Virgin Islands. And these groups are really becoming very active. Every year, they're becoming more active. Next slide.
And I would note, Robert, that particularly in the Sun Belt.
Yes. And I know that you're currently handling several of those Mafuku prosecutions in Virginia right now.
That's right.
So, some states are more active than others. Texas has always been very active. Virginia is probably, believe it or not, the most active when it comes to personal care prosecutions. Louisiana, not so much on the personal care side, but they really have been very active in the last few years on the hospice side, which we're going to talk about in a few minutes. Now, this is just kind of a sideline comment, but this was based on a report that came out recently from the U.S. Sentencing Commission. And I thought this was very interesting, John. What they did was the U.S. Sentencing Commission, under sentencing guidelines, if you have an effective compliance plan in place, and it's something that is real, and you're actually trying to follow it, you can show the government that. If a problem does come up, you can get some type of remediation. You can get some kind of credit for that when it comes time for the government to decide what they want to do. Interestingly, out of all the companies out there, the organizations that were criminally prosecuted, only 11 of them out of 5,000 had an effective compliance plan in place. Now, I think that this is really important. All of these, of course, weren't healthcare, but it really kind of gives you a sense of the fact that so many domestic companies don't really have an effective compliance plan in place, and they really should. Not just because it's going to help protect the company, but most importantly, it's going to help protect the individuals working at the company, the owners, the managers, the supervisors.
Yeah, Robert, this reminds me of that old commercial that you and I remember. I don't know if our listeners will remember the Fram oil filter, where you could buy a $10 Fram oil filter now, or you could replace your engine for $1,500 later. It's the same way here with healthcare.
Yes, it is.
Now,
it absolutely is. Yes, it absolutely is. Okay, next slide. Now, we're focusing today on criminal liability, but that doesn't mean that we can ignore the administrative side. And the reason for that is, as John will tell us, a lot of the cases that we're getting these days on the criminal side, they started out as an administrative review. And there are organizations out there like UPICS, Unified Program and Integrity Contractors, whose job it is, first and foremost, is to identify fraud. Now, most of the time when they conduct an audit, they may have conducted the audit based on data mining, and that's really how most audits are generated. And they have reason to believe that, based on the reviews that we conducted, we have real concerns about how and whether or not these services being billed are actually being provided, or are they being billed correctly. But the UPICS, their job is to identify fraud and to make referrals to DOJ and to the OIG whenever possible. John, do you have anything to add about the UPICs?
Yeah, the main thing I want to add is that it goes back to the previous slide. If the listeners will get aggressive with front-end compliance, then there won't be any administrative problems with UPIC to see, and there won't be any referrals farther down the road. So just like with compliance, get help early, get to your healthcare professional when you first think there may be a problem or before a problem so that it never arises.
That's right. That's right. Next slide. And I will tell you, from my perspective, most of the cases against home health and hospice agencies, they have two ways of originating. One is on the administrative side. The other is, on the conduct side, primarily kickbacks. And we're going to talk about those in detail in this presentation. But one thing I'd like to point out to you, UPICs, I mentioned the fact that their job is to identify fraud. If they identify conduct that looks like potential fraud, it is in their contract and it's in the Medicare Program Integrity Manual. They must refer these cases of potential fraud to the OIG. Okay, now many times they make a direct referral to DOJ at the same time. So you really kind of have to be careful, because whenever you're audited by a UPIC, you may think, oh, it's just another routine audit. There's nothing routine these days about a UPIC audit. You have to be very, very careful. Next slide. And this really kind of, I think, lays out the likelihood of a referral. I will tell you, most UPIC audits, when they're through, all they've done is identify a possible overpayment that you have to pay back, okay? But that's not always the situation. In some situations, if they identify potential problems, they can recommend a payment suspension. They can also recommend the revocation of a provider's billing privileges. And these get more serious and more serious because, these days, of course, a revocation can be for up to 10 years. And then in the most serious cases, if they identify evidence of fraud or illegal conduct, then they can make those referrals directly to DOJ and to OIG for civil or criminal prosecution. So, next slide. The bottom line is, whether you're placed on prepayment review, whether you get a request for an audit from a UPIC, or if you get some type of audit request from the MAC, you have to take it very seriously. You cannot ignore them. We've had cases recently where a home health agency received a couple requests for records. They didn't turn them in time, and as a result, the claims were automatically then deemed to be denied. That then was used later on as a springboard for the MAC and based on the UPIC's reviews, to suspend the provider from participation. So little things like ADRs, TPE audits, even CERT audits. It's very important that you take all of these administrative requests serious, okay? Because they can lead to more serious actions if you don't. Next slide. John, you want to talk about, with the next few slides, we're going to talk about some of the common criminal statutes that come up in home health and hospice cases. You want to kind of run us through some of these?
Well, I'll do it from a 30,000-foot level, but the 18 U.S.C. 1347 is the healthcare fraud statute that was enacted. I believe it was at that same time during Attorney General Reno to create a focus on protecting the Medicare trust fund, and that makes it unlawful for anyone to defraud a healthcare benefit program. Now, originally, it had to be a government program, but not anymore. Now, any private insurance company can also be a victim of a crime under 1347. The important thing to know about that is that, of course, HHS-OIG, they've got their bank of investigators investigating criminal cases on behalf of Medicare, but so does every insurance company. They've got a bunch of retired HHS-OIG folks investigating what they believe are crimes against them. Anything that an insurance company that has a board and is bottom line oriented, anything it can do to save money or recoup money is good for their shareholders. So they will be very aggressive at finding anything. So every provider who takes any kind of either government insurance or private insurance needs to know that there are criminal tools to go after them, and investigators will aggressively do it if they're given an angle. And obstructing a federal audit, anything done to impede trying to collect the records to review whether claims have been appropriate or not can also be a crime. Next slide.
Okay. Now, this is interesting, John. I mean, there is a criminal false claim statute. So can you also differentiate for our listeners? What's the difference between the criminal false claim and a civil false claims act action?
Well, that's the interesting thing, Robert. There really is no difference. There's the same conduct that could constitute a civil false claim could also support a criminal prosecution for submitting a false claim for payment from the government. So it's, and I'll tell you, that's where lawyers, we tear our hair out sometimes wondering why isn't the government treating this as a civil case. There does not seem to be the level of intent or wrongdoing that should make this criminal conduct, but the government may be investigating or prosecuting it as a criminal case because of a pattern of submitting claims for payment that the government deems are false. The most egregious falsehood to submit to the government or private insurance for a payment is billing for services not rendered. So that's, if there's a pattern of that, there's certainly going to be an inquiry, and that's the most significant false claim. If it's, let's say, upcoding, alleging that more time or attention was spent with a patient than maybe the code describes, that's not going to be viewed on as seriously, and maybe the government would take that in a civil direction instead of a criminal direction. But you can't be sure by any stretch. So the same conduct would support either pursuit by the government, criminal or civil.
Okay. And what about false statements and other statements and entries?
I think the important thing to remember here, and we'll get to it later in the slides, but anytime that you submit something to the government in writing that has material misrepresentations on it, or anytime you speak with an officer of the government, like an FBI agent, for instance, and the government deems there are falsehoods, then you can get in trouble and be prosecuted just for the false statements. I know this is an overused analogy, but the most famous one is Martha Stewart, who was investigated for insider trading, and they never prosecuted her for any securities violations of insider trading. They prosecuted her for lying to the FBI agents who came out to investigate that insider trading. So both are crimes, and you don't need to be convicted of the underlying offense to be convicted for lying about whatever the underlying offense was.
Okay. aggravated identity theft. Now, this is kind of this was a very popular charge to throw onto indictments until, gosh, this summer, wasn't it? And then the Supreme Court kind of throttled the government back a little bit, saying you can't throw this in every time that they get something wrong.
The statute was originally intended, it seems apparent on its face, for taking someone's identity and adopting it and then going out to commit crimes as if you were someone else. The government started adding it on that anytime a provider made a claim that involved personal information like healthcare and a claim for payment, that can be, you can be charged with misusing someone's identity. And the problem was that it added a 2-year term of imprisonment to whatever other penalty there was. So finally, the Supreme Court reined that in, and we're not seeing much of that anymore. Now the government has decided that it was overcharging that. So we don't see it tagged on with healthcare as much, and thank goodness for that.
Yes. Okay. All right. So those statements or those criminal statutes, John, we see those occasionally in home health and in hospice cases, criminal cases, but that's not really the primary statute that we see, is it? The primary statute is really the anti-kickback statute. And the anti-kickback statute has been around a long time. It goes back to 1972. And interestingly, at that time, it was just a misdemeanor. It wasn't until 1980 that they actually started to require proof of knowledge and willful conduct. Next slide. And then most recently, of course, they amended it under the Affordable Care Act, so that they no longer require, it's gone through a lot of changes. Now it's a felony, of course, and it can be fines up to $100,000, but you don't have to have actual knowledge anymore or specific intent. Can you kind of comment on that?
Well, there's a willful blindness standard that they've lowered, if you will, the anti-kickback statute to include, so that and bear in mind, listeners, that the whole idea here is that a provider should be making decisions about patient care, certainly in the eyes of the government, solely based on whatever the circumstances are, and shouldn't be the health circumstances shouldn't be influenced in any way by any sort of remuneration that may be passed on to that doctor, which the government would see as an incentive to make a decision more aggressive rather than less aggressive. So now you don't have to have the same level of intent. That as long as there's a payment that happens, and you know about the payment, even if it could be viewed as part of the payment for services, the government can view that as a violation of the anti-kickback.
Yep. Next slide. And under the anti-kickback statute, as I said, it can be a fine up to $100,000, 10 years in prison. It's extraordinarily broad. And in the Fifth Circuit, they have adopted what they call the one purpose test. And what that means is, even if there were a bona fide reason for you engaging in the conduct that you did, if one purpose of that conduct was intended to induce referrals or compensate someone for helping with those referrals, it's still a violation of this criminal statute, the anti-kickback statute. So it really is quite broad. And that's when we start going over the examples of recent cases, you're going to see that most of the cases brought in home health and hospice matters have involved some type of kickback allegation. Next slide.
if I could just
Yeah.
add there, Robert, that of course, when Robert refers to the Fifth Circuit, that includes Louisiana. And of course, the other provision is the civil monetary penalties. And so even if even if there's a probationary sentence, let's say, with no custody, the civil monetary or the criminal monetary penalties, they are just by their definition, they're penal. They're meant to cause pain, and the government can take a much bigger bite through the monetary penalties than even through custody.
Yep. Now, John, one of the points that you made a few minutes ago when you were talking about the criminal false claim statute and its relationship to the civil false claim statute, I think is really instructive here as well. One of the things that happened under the Affordable Care Act is the legislation said, hey, in the future, violations of the criminal anti-kickback statute now will automatically also constitute a false claim for purposes of the Civil False Claims Act. And this is, we talk a lot about prosecutorial discretion. And this is one of the things that's so frustrating because in Louisiana and especially in Texas, there have been a number of anti-kickback violations that were, in my opinion, the damages to the government were very small. But the government still chose to pursue those criminal violations, those kickback violations, still chose to pursue them criminally. While in other parts of the country, allegations of violations of the anti-kickback statute many times have not been pursued criminally. The government chose to pursue them civilly under the False Claims Act. So, what's your view on that, John? Because there is so much discretion when it comes to the government and the prosecutor handling the case, deciding, am I going to pursue these criminal violations criminally, or am I going to go over them civilly, or am I going to do both?
Robert, when we have cases in Louisiana and Texas in particular, and I was just at a meeting in New Orleans a couple of weeks ago, it seems like the prosecutors, the government attorneys, so often tell us, well, of course, here in the Fifth Circuit, and that's a preamble to the government has more discretion and bite here than elsewhere. So you really need to pay attention and come around. That seems to me what they're saying. So the only thing that I can rationalize in my own mind is that that there are more retirees that go south, and so there are, perhaps more Medicare claims submitted in the South, and so the government and the prosecutors are more vigilant. That's the only thing I can make of it, because I agree with you. We tend to see cases that are being prosecuted or investigated criminally that don't strike us as more than a civil violation for our cases elsewhere in the country.
Yes. Next slide. So, John, when we looked at the definition of the anti-kickback statute, I mean, to kind of distill it down, and you tell me if you want to add anything to this, but it's basically if you provide anything of value in an effort to induce a referral, that can be a violation of the criminal anti-kickback statute. And the problem is that definition is so incredibly broad that even the government admits that it's so broad that the government has had to come in and say, well, yeah, that's pretty much what we're trying to do, but we think it's okay if you're doing this conduct over here, as long as you meet certain requirements to kind of reduce the likelihood of abuse to the Medicare system. We think that conduct may be okay, even though technically it's a violation. And that's called a safe harbor. Is that right, John?
Yeah, and so many of our cases, Robert, it's apparent that people unsophisticated in the medical field will get involved with conduct where it's clear that whoever has gotten them involved has tried to carve out conduct that they ask people to do within a safe harbor. And then when it turns out that, well, they didn't consult a lawyer about whether that was actually in a safe harbor, and then in the middle of a criminal investigation, the person who's being investigated is like, yeah, but they told me this was okay. They told me this was what they call a safe harbor. So it's very broad, and we see it a lot in the context of marketing within your industry, where people are brought in for marketing purposes and told, oh yeah, this is in a safe harbor, and then the next thing they know, they're being criminally investigated. So it's very broad, and it tends to be what did the prosecutor have for breakfast that may determine whether a safe harbor exists or not.
You're right. And there are a number of safe harbors. Congress has created 11 of them. Those are known as statutory safe harbors. And then the OIG, the Office of Inspector General, through the rulemaking process, they have established 36 regulatory safe harbors. So, they create this overly broad law, and then they realize, oh, that's way too broad. We need to make some exceptions for it, although they don't call it an exception. That's really an exception, a term of art used under Stark. But we need to create a safe harbor for it, and they end up having to do 47 of them just to make it to where providers can still do business. It's really crazy. Now, in the world of home health and hospice, there are two primary safe harbors that you guys really try to fall within, okay? And we'll talk about these. The first one, personal services and management contracts, all right? Well, there's a couple of different areas where this might come up. You may have a medical director. Okay, medical directors are currently an area of great concern for the OIG. And for those of you who have multiple medical directors, that's kind of a red flag for the government. So we'll talk about, your contracts with those medical directors. In order for them to be legal, they need to fall under the personal services and management contract safe harbor. Okay, and then there are other individuals. Maybe you've got marketing people. Well, a marketing person, more than likely, it's tough. I mean, it's theoretically possible they could fall under if they're a 1099, they could fall under the personal services safe harbor if they meet certain requirements. But a lot of times you want these people to be employees. So we'll talk about these two different safe harbors now. Let's go to the next slide. The first one that I want to mention, the personal services safe harbor. They made some changes to the safe harbor that they kind of loosened up certain parts of it, but they still kept the core requirements. And those core requirements are, if you go down about halfway down there, down the page, the methodology, it's got to be, you've got to pay somebody. So let's just use a medical director as an example. The amount that you're going to pay him has to be set in advance. It's got to be consistent with fair market value in an arm's length transaction. Okay, well both of those things can be problematic right off the bat if you're wanting to pay your docs an hourly rate. And then this is the most important. It can't be determined in a manner that takes into account the value or volume of any referrals made. Okay, so medical directors, in a perfect world, your medical director for your home health or your hospice is going to be somebody who doesn't send you any referrals at all. Okay, that really, from a enforcement standpoint, that's the safest way to handle medical directors. That's not real life though, because in a lot of your communities, there aren't that many doctors out there to begin with. And anybody that you're going to want to be a medical director, chances are they're going to be making referrals to you. It's so important that you realize that the government is going to be looking at, well, it's so interesting, this doctor's being paid X amount of dollars, and it also happens to be, the source of the largest number of referrals for this home health agency. So they're going to look at, what are you paying them? And is it fair market value? And I will tell you, one of the things they're also going to examine is they're going to examine, okay, well, what exactly is the doctor doing for this monthly amount that you're paying them? And they're going to want to see evidence of that. They're going to want to see notes. They're going to want to see how often did they come in and do the medical director duties. What are the medical director duties that they're going to be required to perform? And they're going to see if you have, or the doctor has maintained records to kind of show that, in fact, the services he or she has provided are bona fide and they're consistent with the hourly rate for the community and its fair market value. If you can't show that, the government jumps to the conclusion, don't they, John, that, well, if there's no real evidence that the doctor is really providing bona fide services, a prosecutor is going to think, well, the only other reason you're going to give this doctor a check is because he's sending you referrals.
So the default of the government goes back to that there shouldn't be any reason a doctor makes a decision that's not based solely on the medical circumstances of the patient. So that if a doctor is paid based on the number of patients going to a particular facility, the default of the government is going to be, well, the only reason he's making that decision is because he's got a financial cut of the action and not because the patient really needs it. So again, that's the fallback position that the government's going to take, and they're going to see it as a kickback and not legitimate services.
So yes, so I would recommend, I know a lot of you get your medical director contracts from your buddies, or you find one on the internet. You need to have a health lawyer look at those contracts and make sure that in fact these contracts meet the requirements that they need to meet, and also make sure that your medical directors are documenting as they need to show that whatever services they're providing you, that those services are consistent with the fair market value requirements and consistent with the requirements of the safe harbor. Next slide. Now, the employment safe harbor. This is kind of a tough one. A lot of you folks have individuals that, I don't care if you call them a community liaison or a marketer or 1,000 things in between. Their job is to go out there and to familiarize the doctors who make referrals to home health agencies and to hospices, familiarize them with the services that you provide. So they're dropping off brochures, they're dropping off informational packets and those types of things. The problem is that these individuals that serve in these positions, a lot of times, a home health or hospice agency, they want to compensate these individuals based on their good work, their success. That's the American way, isn't it, John? So if you've got a marketer that works very hard and he's able to gin up 10 referrals a month, it's only natural for that individual to want to be paid based on his success, and the agency wants to pay them based on their ability to generate business. The problem is, if you recall, when we just looked at the personal services safe harbor a second ago, you can't do anything there where you're compensating someone based on the value or volume of referrals that they're able to generate. So a marketer is almost, if you're going to want to pay them that way, they almost never meet the requirements of the personal services safe harbor. So sometimes what agencies will do is they'll try to say, well, this individual is not a 1099. This individual is a W-2 employee. Well, the problem with doing that is the government is very skeptical about these individuals of whether or not they really are a bona fide employee. And we have had a number of cases where we have to go in and argue that the individual is an employee, and the government says, well, you may meet some of these requirements of an employee, but we don't think it is an employee, and therefore, if it's not a bona fide employee, they don't qualify under the employment safe harbor. Because the end of the employment safe harbor, if it's a bona fide employee-employer relationship, okay, then you can pay them however you want, okay? You're not tied to that restriction against value or volume. The problem is that many times, perhaps most of the time, the marketing people are not really bona fide employees. A lot of times they're working for 2 or 3 different agencies. They've got another job on the side. You're not really providing them with the proper training. You're not really supervising the work, giving them the instrumentalities and tools. You know, there are a bunch of factors that the Supreme Court and the Fifth Circuit has adopted this, by the way, have said these are the factors we're going to look at when we're trying to decide, is this in fact an employee? Tax treatment is only one. So the fact that you're taking out taxes, that's only one factor. And that is not a determinative factor. That's something that the government's going to, you know, almost every case we've had, the person was being paid as a W-2, but the government still said they're not a bona fide employee. So we would have to go in and argue all these other factors. John?
As you mentioned, the thing that's antithetical to so many is that in the marketing/sales world, in every other industry, they can be paid based on performance. So when they move laterally into the healthcare field, their instinct is that's how I ought to be paid. And if they're approaching someone to say this is how I want to be paid, they might not realize that they're stepping on a landmine in the healthcare field. And the other point that I would make here is that so often what we see is that somebody being hired, let's say a marketer, is given a contract and said, yeah, this has been reviewed by the lawyers, everything is in compliance. And it turns out that it's a contract that was used in another context. And without consulting a lawyer, the employer has just cut and pasted and given it to someone, say this is in the employment safe harbor, you're okay, here's the contract, and it's not. So if you are offered in any time in healthcare, you're offered a contract to say this is why it's okay, your best bet is to have your lawyer review it to make sure that it's actually compliant under the circumstances that you're in.
Yep, that's a good, excellent point. And the other point, John, that you've made in a case recently was the contract on its face was proper. But the fact is, in real life, that stuff wasn't happening.
That's right. So the contract may say, we're going to do X, Y, and Z, and that's why it's okay. And it turns out instead they were doing ABC, but they never even actually read the contract to realize they weren't doing what the contract said they were going to do.
Yes, yes. And we've seen that in several different contexts, not just home health and hospice, but physicians, their relationships with third parties, pharmaceutical companies, all kinds of things. You know, a contract is only good if you're actually going to adhere to the requirements under the contract. So, gosh, you got to be very careful. Next slide. Now, just one other thing here. We talked a lot about fair market value, okay, and we talked about that primarily in the context of the personal services safe harbor. You know, when you're dealing with the medical directors. OIG is looking, you know, this isn't anything new. They first issued a fraud alert in 2015 about these physician compensation arrangements, okay? The medical director agreements are a perfect example of that, okay? But this has raised its ugly head again just in the last year. And OIG is looking at these issues again, you know, and they're very concerned about these medical directorship arrangements. And you have to be very careful that these docs, you know, you're not paying them for the amount of the value or volume of any referrals that they're sending. Whatever you're paying them has to reflect the fair market value for the services that they are in fact performing. All right, so John, you want to start us out talking about some of these home health fraud cases that are out there?
Well, I guess an important thing to bear in mind is these are different federal districts. These are federal cases, Northern District of Illinois, Southern District of Florida, Northern District of Illinois, and they're all that. Even though there's tremendous focus where you are in Louisiana, there's focus everywhere, and anytime that there's a circumstance where the government can allege that there's a kickback, that they're going to give it a close look. So in the first one, there was an allegation of a marketing arrangement that didn't exist, and instead they determined that that the agency owner was simply writing checks to himself and using it to make cash payments as kickbacks to the marketers. So it wasn't for the market value of what was being provided. Instead, it was they were basically laundering money in order to pay kickbacks. And Robert, you want to take the second one?
Sure. In the next one, it was an interesting case. Once again, it's another kickback case, and the marketer was paying kickbacks to the beneficiaries. Now, this is something we don't see as much as we used to, and we used to see it a whole lot in Florida, but it still comes up. These are recent cases, and in this particular case, they were paying kickbacks to the beneficiaries to recruit them to be referred to home health agencies. So they would actually coach the patients to go in and what to say in order to get prescriptions from their doctors. And then when they came out with these prescriptions, they would say, okay, now we want you to go and ask that ABC company be the home health agency that you get help from, and we're going to give you X amount of money or X amount of dollars to do that. So, here we had the marketers paying kickbacks to the beneficiaries. In the next case as well, it was a little bit different. It was a consulting company that was supposed to handle the billing for 20 home health agencies. And while they were supposed to be doing this, one of the individuals at the company submitted all these fraudulent claims to Medicare that resulted in $40 million in payments for services that were never rendered. So, this is a consulting company that was based in Pakistan, and they were supposed to handle the billing, and this is kind of what happened. Now, they didn't say exactly what happened in this case, but I'm sure that it's very common for a billing company to be paid a percentage of collections, and it's very possible that they billed for all these services not rendered, because that, of course, would give them more money. Next slide.
You have to be careful who you're outsourcing to and know who your partners are.
Exactly. And I will tell you that Florida has actually passed a statute now that says that you cannot send PHI overseas anymore. Only Florida has done this. There are some states where they have made it more difficult for Medicaid records and billing and the rest of it to go overseas. But at this point, it's not against the law, but there are definite risks that you have to take into account. Now, all of these cases, and these are all recent, were all out of Texas. I will say that there hasn't been that much activity for Louisiana over the last year when it comes to home health. But your cousins there in Texas are very, very active. here they're in the first case, the owner was paying recruiters and doctors to bill for Medicare using the beneficiary information. In the second case, they were paying kickbacks for patients to sign up. That's the same thing we saw in Illinois just a minute ago. And they were paying kickbacks to the doctor to certify and refer patients that really didn't even qualify for home health to their agency. Okay. Another case in the Houston area, same thing. They were paying others to certify that the patients were medically needy and qualified for home health. And then in this last case, once again, they were found to have been billing Medicare for services for patients that were not medically necessary or were not provided. And once again, they were also paying for patient referrals. So, we wanted to go over some of the various criminal statutes that you're likely to run up against with a home health or hospice agency. But I think you can see from these recent examples, the primary problem is the kickback statute. That's really the one you have to really watch out for. Next slide. Now, hospice agencies. You want to talk about these hospice agencies, and both of these are Louisiana.
So in the first one, this goes back to the use of the federal statute 1347 for healthcare fraud, billing at the wrong level of care. Interestingly, in this one, since the government alleged that they were not hospice eligible and shouldn't have been billing Medicare for that care, its level of care. And along the fraud continuum, in the last slide, we saw that it was services not rendered and services that were not medically necessary. Along the fraud continuum, this one's even a step lower, that it's just the wrong level of care. They weren't quite eligible for hospice, maybe care, but not hospice care. And yet they were prosecuted as a healthcare fraud. The next, I'm sorry, go ahead, Robert.
Nope, I didn't say anything.
Okay.
All right, next slide. Okay, so these are, and we're kind of out of time, but we'll go through this pretty quickly. These are kickback risk areas. So you got to be really careful. Medical directors, we've talked a lot about those. You can't give anything of value. Remember, if you provide anything of value in an effort to induce a referral, that's a violation. So cash, the government hates cash. They really don't like cash, gift cards, gifts. One thing that they always have a problem with, we're sitting here at Christmas, guys. I know you're probably going to want to send something to your doctors who have been so good to you and you have a personal relationship with on some level, but you got to be careful. Technically, that fruit basket, could be construed as a violation of the anti-kickback statute, even though it may only be worth $25. There is no de minimis under the anti-kickback statute, okay? Now, have I ever seen a prosecutor go after somebody for a fruit basket? No, have not. But it doesn't mean that it's not a potential violation. And one thing I do want to point out, one thing that the government always has a real problem with is liquor, okay? So, if you're going to take that risk, and we can't stop you, of course, from doing that, you're going to do what you're going to do. But if you're going to send a Christmas present over to your friends and relatives and potential referral sources even, you got to be very careful. You have to understand that you are taking some risk there, but make sure that it's not liquor, okay? The government never likes liquor, and we have seen so many cases where they have thrown that into the complaint in False Claims Act cases, because there is no reason for you, even to say just season's greetings, Merry Christmas. They don't think that liquor is appropriate. John?
Does that include fine wine?
even bad wine. So just be careful, guys. But You know, I mean, it's common to send the Christmas season's greeting fruit basket, but I'm just telling you, from a technical standpoint, it can be problematic. It can be a violation of the statute. Next slide. Let's talk about some non-kickback problems that we've seen. You know, medical necessity. We saw 2 or 3 cases in those examples where they said that the services weren't medically necessary. And really the question comes down to this. I mean, remember, no one's going to audit you for care that you provided last week, okay? I mean, a UPIC could do it, I suppose, on a prepayment audit, or you may get a TPE audit, and it could be prepayment, and that is possible, I suppose. But most of the time when you're in real trouble, especially in a criminal case, they're looking at claims from 3 and 4 years ago, okay? And if you didn't properly document medical necessity, it's especially difficult sometimes with hospice, because the requirements under an LCD can be so specific depending on the diagnosis of the terminal illness. If you don't document medical necessity, okay, you've got a real problem, because you know it's going to be years from now before this pops up. The doctor that may have worked up the notes is long gone. The nurses that worked on the case with the patient, they're probably gone too, because your turnover is so high, and you're going to have a real problem. Failure to sign the EHR treatment notes, that's something that comes up all the time. Missing treatment plans and consent forms, that pops up. Allowing unlicensed staff to provide care. Gosh, I know it's hard to hire nurses. I know it's hard to get qualified staff. But you have to make sure that the people providing the care meet the requirements in the state, okay, and that they're properly licensed, okay? All right, John, I'm going to have you do the lead on this, but the fact is, well, first tell us, John, what is a 302?
Well, let me give you the overview of this slide. We'll do it quickly because we're running out of time. The 302 is just the standard FBI report. And believe it or not, in today's day and age of technology, when the FBI interviews somebody, they don't record it. So if you, as the person being interviewed, has a dispute later with what you actually said and how you said it, that's not going to be recorded. And instead, it's just the second agent who's sitting there not asking the questions, taking notes. It's going to be that agent's impression of what was said and how it was said that's going to be recorded. So the long and short of it with this slide and the coming slides is, if the government comes out to speak with you about in an investigation, it's going to seem harmless. It might seem harmless. And your response needs to be one thing and one thing only. Gentlemen, ma'am, I want to cooperate every way possible. I'm going to, as soon as I get my lawyer here, we're going to cooperate with you and make sure that we get to the bottom of this. So you're going to tell them you're going to cooperate. You're just not going to do it until you have a lawyer, because I promise you, they are going to elicit things that you didn't intend to mean with what is said, and that's going to be twisted and turned around, and it's never a good thing. You always want a witness, and you always want that witness to be a lawyer.
Next slide. And the fact is, they can lie to you, can't they, John?
Well, they can. I mean, it's as an investigative technique, as long as it's not outrageous. So, you know, just because you admitted to something that you wouldn't have admitted to had they not lied to you, that's not going to be a defense later. It's the bottom line with all of these circumstances is, no matter what the agents do or don't do, whatever they record or don't record, anytime you're speaking with a government investigator about your business or anything else, frankly, be sure to say, I'm going to cooperate. As soon as my lawyer is here, we're going to talk this through. And then you let your lawyer do the talking, because anything your lawyer says is not evidence. So you can tell your lawyer whatever you want the agents to hear, and they can't charge false statements against the lawyer is just representing somebody, and they can't charge you with false statements if your lawyer says it. So just make sure that whatever you communicate to the government, you're doing through a lawyer.
Next slide. I think we've covered this one. Why don't you go to the next and then the next one? Okay. And John, I think that this really kind of makes your point. This is a recent case that just came out in September out of Spokane, Washington. And they were doing an investigation of the controlled substance prescribing practices of a doctor. And when the FBI interviewed the provider said that 99% of the time, he checked the vital signs of the patient before prescribing an opioid medication. Now, ultimately, they didn't charge the provider with any billing violations. They didn't charge him with any controlled substances violations. But to your point, John, they charged him with lying to the FBI because when they looked into it, the government said, and this is a quote from their press release, the rate at which the clinic performed complete physicals was materially lower. Wow. So, John, what about that where, you know, you've got a doctor, he's just using hyperbole, kind of talking off the cuff. Next thing you know, that's the basis that they're going to charge him with a crime?
That's right. It's, you know, you can just hear, you can hear yourself. I can hear myself saying that respond to something. Oh, 99% of the time I do that. When maybe it's 50, maybe it's 75. But what's materially lower? It could be 90 versus 99. But the whole point is, instead of telling the questioning agent, yeah, I mean, I try to do it all the time. I think I do it all the time. I know it's important. I believe in doing it all the time. You know, instead of saying it like that, qualifying, say, oh, 99% of the time I do that. And all of a sudden that's a crime. So I just go back to what I said before. Anytime you talk to a government investigator, make sure your lawyer is there, and your lawyer is going to make sure that he or she's doing the talking, believe me.
Yep. Okay. Next slide. Okay. So, John, what about these recommendations on responding to an investigation there?
Oh, you know, it's the most important thing. We want to harp on this. We've started the program saying it. We're going to end the program saying it. Please consult counsel. Please do it early so that you get guidance early. You should do it to create a compliance plan so there are never any problems. But at the first sign or smell of a problem, just contact counsel and let the attorney straighten out, is there a problem? Because the attorney's going to be able to do his or her own investigation. Going to make sure that all the documents are retained, because that's another thing you don't want to do. You don't want to be charged with obstructing an investigation because documents are not retained. And you want to let first of all, you want to have good employee relationships, period, so that nobody becomes disgruntled and becomes a whistleblower for something that is or isn't true. But then you want to be able to have your lawyer assessing the employees if there's an investigation and determining whether somebody might be a whistleblower or whether that somebody's involved with wrongdoing that you don't even know about. So with the guidance of counsel, you're going to be able to get out in front of whatever issue there may be and straighten it out as it can be straightened out. And then if there's both criminal, civil, and then maybe even administrative issues, the lawyer is going to be able to make sure that it's all wrapped up in one resolution and you're not going to have things dangling out there.
Okay. We've got a couple more slides here for the final thoughts. Just very quickly, check your LCDs, especially for home health and hospice. They change all the time. Depending on the jurisdiction, for hospice, it can either be very broad or it can be highly, highly specific for each terminal illness. So it's so important that you keep up with the rules as to what's required to qualify for coverage and payment. Very, very important. Next slide. And then, guys, to avoid kickback problems, look at your financial relationships, okay? Very, very important. One of the things the government does when they come in, one of the first things that DOJ or the OIG does is they look at where do you get your business from, where do you send business to? That's the initial set of questions, and that's going to drive a lot of their investigation. You have to make sure that whatever business relationships you have, that those are compliant with all the rules that are out there, so that you're not violating the Civil False Claims Act, the Anti-Kickback Statute, or Stark on the home health side, not on the hospice side. So it's really, really important that you do that. Next slide. Okay, that's our contact information. There was one question. It was a pretty complex question. I would ask that person just give us a call, and we're happy to deal with the question that way. It wasn't something that we could answer in the next few minutes, and we're already pretty far past time. But we really appreciate you taking the time to come in today and go through the presentation with us. And as always, if you have questions for me or for John, give us a call. John, any last words?
Nope, just contact your lawyer, do it early, do it often, and trust your lawyer.
All right. Thank you, guys. Thank you, John. Thank you, Robert. That concludes today's webinar. Thank you all for joining us. And everyone from today's webinar will receive copies of the presentation slides to your email. And we will see you next time. Bye-bye.
Thank you.